Investigative journalism isn't just news. It's the art of uncovering the secrets that others wish to keep hidden. It's about asking the tough questions and digging deeper when the surface tells only part of the story. From exposing wrongful convictions to shining a light on political corruption, this brave pursuit faces the shadows head-on. It demands time, patience, relentless curiosity and the courage to follow the truth wherever it may lead. In a sea of quick headlines, this vital work reminds us that sometimes, justice depends on someone who dares to pay attention.
Welcome to Spoken in Justice, where we put the criminal justice system in the dock. Today I'm joined by someone whose work has helped to uncover truth, challenge institutions, and shed light on stories that many would rather keep buried. An author, television producer, and formerly investigative journalist, with part of his career spent digging into miscarriages of justice, he brings deep insight into how the media can influence and sometimes correct the course of justice. I'm thrilled to have Steve Phelps here today to talk about the role of investigative journalism and his thoughts on how bodies like the Criminal Cases Review Commission could evolve for the better. Welcome to Spoken in Justice, Steve. We are truly grateful you could join us today. It's an honor to have you on the podcast.
Well, thank you very much for inviting me. I hope I can contribute something.
I'm sure you will. I thought probably it's good to start with some personal and professional background. Could you tell us a bit about your career path and how you came into investigative journalism?
Well, after I left university, I wanted to work for the BBC because my school was very close to Television Centre, and I used to ride my bicycle up and down past Television Centre every day. So that's what I wanted to do, and I failed to get a job in the BBC, and I didn't really have any other ideas. And so I wasted about 7 or 8 years of my life doing all sorts of things that I won't bother to tell you about. But then in the end, I did get a job in the BBC, first of all in radio, working on a rather wonderful programme called Going Places on Radio 4, which was about transport. And it was quite interesting because transport covered really everything that moved. So we were able to look at anything we wanted. And it was quite a political programme. So that's kind of where I learnt something about the power of journalism politically, you know. But I always wanted to work in television. So then I went to television for the beginning of breakfast television. And fairly quickly then I moved on to Watchdog. And when Watchdog, in the early days of Watchdog, when it was being set up as a regular programme on its own, I became the deputy editor of Watchdog. And I did that for about a year and a half. And, you know, once again, that was, you know, a consumerist programme taking on governments and institutions and companies and trying to set things right. And as a result of that kind of work, I was then asked if I would go and take over as producer of Rough Justice at the BBC. I did that for 18 months and then various other
What
things.
year was that, Steve?
That was 1987 that I started there. And those of us doing the programme then were really, we didn't think the BBC was committed to Rough Justice, and we were very worried that they would give up on it. And so we took the idea off to Channel 4, and they bought the idea, and we set up a company called Just Television to make, in effect, Rough Justice on Channel 4, which was called Trial and Error. And we did that for a dozen years, and I'm sure later on we'll talk about why that came to an end, but that's the background.
Fabulous. And what kinds of stories or investigations were you most drawn to during your time as a producer?
Well, I mean, I have to say that when I was asked if I wanted to go and become the producer of Rough Justice, that to me was the pinnacle. because, I'd always been interested in injustice. Um, Ever since I felt a couple of injustices were meted out to me at school.
Oh.
And I also had some experience of the criminal justice system and how it could work positively. And it was very interesting, really, to start to get involved in situations where it had gone wrong. And of course, the wonderful aspect to this work is that at one and the same time, you are acting for an individual who is powerless in themselves because they're locked away and they're incapable of fighting their own battles. But at the same time, you're taking on the mightiest engines of state, who are, really moving heaven and earth, not to have their systems overturned. So, that to me is the pinnacle of investigative journalism.
Indeed, and it's a great challenge.
Mm.
Is there a particular case or investigation that has stayed with you over the years, and why?
Well, there are a number of cases. I mean, the first rough justice I ever did was about the Darvell brothers in Swansea, and the Darvell brothers were two down and outs who were arrested and convicted of the murder of the manageress of a sex shop. And we used to give titles to the programs in those days, and that one was called A Convenient Conviction because it tidied things up for the South Wales police. Whether they'd actually got the person or people who murdered Sandra Davis was another matter, and these guys were an easy mark. But what made that very special really was that it was rather difficult to get past the BBC because, and I don't blame them for this, if you want to take an audience of several million people with you, it's that much more difficult if they don't empathize with the subject matter, and the BBC thought, well, is anybody going to watch a program that's actually battling for these kind of, hopeless individuals that, were expunging off the state or whatever, and they were rather looking for, nice middle class murderers in inverted commas. And we had a few of those as well. But, that one stuck out for me. And then there are also a number of others where we made programs about them, and we would only make a program, obviously, if we were 100% convinced of their innocence and factual innocence as opposed to technical innocence. Because I mean, not a trial that had gone wrong on a technicality, but somebody who actually did. And there are a number of those where we made very good and very persuasive programs, but they didn't result in the conviction being overturned. And some of these people were actually later released, so they're free now, but they may have spent 17, 18, 19 years in jail for something they didn't do, and that rather, that sticks with me, and you never kind of wave goodbye to these things, and it's always possible to go back and revisit them and overturn them, and we might come on to something about that a bit later as well.
Brilliant. Back then, how did investigative journalism play a role in exposing miscarriages of justice? And is there anything fitting that role now?
Nothing fitting the same role. I mean, I'll tell you the story of how it came about, actually. And this is the original series of Rough Justice before my time. And there was an organization called Justice, still exists, but Justice is now more about law reform than it is about wrongful convictions. But in those days, they were looking into wrongful convictions. And there was a television. Right, yeah. There was a television producer called Peter Hill who met Tom Sargent, the man who ran Justice. And they came up with the idea of a television program about it. And the first series was a series of 3. And it was very successful. And there were lots of people, success has many fathers. So there are lots of people who claim to have invented Rough Justice, but it was really Peter Hill and Tom Sargent who were at the bottom of it. Now, Justice was made up of a bunch of retired QCs and judges and so on, and they were very concerned about these series of cases. Of course, what happened when Peter Hill came along was he was given the best three cases, the most cast iron miscarriages, as it were. And they make a program, and they're very, very persuasive, series of three. And the legal establishment said, "Isn't this marvelous? The television is doing a wonderful job." But it was so successful, of course, the BBC asked for another series. And so they go back to Justice and ask for some more. Well, they're obviously their numbers 4, 5, and 6 on the list of concrete miscarriages of justice, persuasive miscarriages of justice. The second series, not quite so well received by the legal establishment. By the time of the third series, 7, 8, and 9, the legal establishment now is thinking, we don't like this at all. These people are usurping our role. And, they, broadly speaking, they were out to get rough justice after that, and they succeeded. And they attacked rough justice, and that original team who did that were taken to the cleaners by the Lord Chief Justice. The BBC took it off air for a while, but to their eternal credit, they did bring it back. I can't remember what the original question was, but that was the genesis of it all. Now, you ask whether anybody's doing that sort of work today.
Yeah.
There are very complicated reasons why you can't do that work today, why nobody is. And to sum it up, really, you need very considerable, not to say almost unlimited resources to do it. You have, and it doesn't fit with the way television or any other broadcast medium really is made nowadays, because television, if you want to commission a television program, you discuss what it's going to be, how long it's going to be, how many they're going to be, and you agree a budget. And the broadcaster, whoever they are, will assign that amount of money. And what the problem with a program like this is, you might do a great deal of work on something and then discover you can't do it. You discover this person actually did do the crime, or we can't possibly make this program. So all that money is wasted. And the BBC, when the BBC was doing it, their budgeting systems were much more relaxed than they are now. And so, they could borrow money from other programs and make it work. And when we set up the company to do trial and error, we did an initial contract to make 6 programs over 2 years. And we wrangled over the contract for a very long time, and we had to insert the words, 4 letters, 2 tiny little words into the contract, so that we were contracted to make up to 6 programs every year, because we had to have a guarantee that we didn't have to make a program if we came to believe that we couldn't categorically state this person was innocent. And those 2 little words were very, very important. And then actually the way we did the programs then, more than half of the budget went on the research process, and less than half, maybe 40% went on actually making the programs, which were made in a very disciplined way, and so that the rest of that budget was not just researching those programs, but all the other cases that were put on our desk, to see which ones we were actually going to do and which ones we couldn't. And so there's no setup like that in broadcasting anymore.
I see. So you covered my next question about challenges that you faced and what challenges new investigative journalists may face today. Have you ever worked on a case that later was reviewed by the CCRC or led to a conviction being overturned? And if so, what was the experience like?
So I'll answer that in a slightly roundabout way. The way that our contract came to an end after a dozen years was, there were 2 things really that happened. One was a new director of television arrived at Channel 4 who had a very different and restricted view of what television was. He thought it was all about entertainment, and whereas we took the view that it's a social instrument. But also, and perhaps more importantly, and one of the things he said was, you people have been agitating for a very long time for the creation of a court of last resort, which was the CCRC. And it had now, the Runciman Commission had reported, and the CCRC had been created. So he said, well, we don't need you anymore, do we? Because we said, no, that's wrong, because whatever the system is, some cases will fall through the bottom of it. And that's the role of journalists. That's why journalism must be separate to whatever systems the state puts in place, okay? But anyway, they didn't buy that argument and withdrew the funding, and then we couldn't do it anymore. But to answer your question then, we were coming to the end of what we were able to do about the time the CCRC started. So in those days, the CCRC was very much better resourced than it is at the moment, and they came on board with a kind of passion to put things right and so on. And the structural problems, the structural fault lines within the CCRC had not yet appeared. So our experience of the CCRC in those early days was quite positive. They were referring cases on the basis of the work that we had done. And some of them got through. A lot of them had already been dealt with. A lot of the cases we were doing during the 1990s had been dealt with because the Home Secretary, through the Department C3, had referred them back to the Court of Appeal, and the convictions had been quashed or whatever. But so some of our programs were still going through the system, through the CCRC and in the appeal court after we'd stopped doing the program. And then we started to bump into a few kind of difficulties with cases that were referred back to the appeal court, and the appeal court turned them down or ordered a retrial. And retrials were not fashionable at all in the 90s, and towards the end of the 90s into the 2000s they became fashionable with the appeal court. But they carry their own problems. And they don't, it's not really a way of getting to the bottom of a situation, and sometimes, the situation gets even more confused. So, we've had people who had a retrial and then were successful at the retrial and acquitted. And we had somebody who was given a retrial, and then there was a hung jury, and then another retrial, and they couldn't reach a verdict either. And then he was released, but without ever having his conviction overturned. So the man in the bizarre situation of being technically guilty, but released.
I see. That's interesting. But talking of the Criminal Cases Review Commission, from your perspective, how effectively is the CCRC fulfilling the mission to review miscarriage of justice today, and what are the limitations, whether in terms of resources, scope, independence, or processes?
You have to recognise that I do not know the minutiae of the situation within the CCRC, so I can't make very precise comments about what's going on. But it is apparent that their resources have been run down very substantially over the years, and the situation was clearly exacerbated by the COVID pandemic, when they began to work from home, the commissioners and the caseworkers, and that we know from the evidence given by the chief executive and the head of casework to the Justice Committee just recently, that they then carried on working in this way and managed to convince themselves that this was a very good way of working, because it meant that they could attract caseworkers and commissioners on a broader kind of geographical basis, because they didn't have to be in Birmingham. But anybody who's done this work will tell you that the fundamental processes of this work are sitting in a room with other people who work with you and know the field, and you sit down and you argue the case of a particular prisoner or a particular point in that prisoner's case, and your colleagues sit with you and attack that proposition and try and undermine it and add things to it. And out of that, the dialectic of that process, that's where you make progress in these things. And you cannot do it if you're dispersed around the country and you're having Zoom calls and things like, Zoom calls are all right for some things, Anna, but not for that kind of work. So, that's what's gone. One of the things that's gone very fundamentally wrong with it, and its resources have been restricted gradually over the years. They don't pay enough to attract the right kind of people, and crucially, they've never been given the appropriate investigative powers. They have a lot of investigative powers that others don't have, but they don't really have the methods to enforce it because they don't have their own investigative arm. And what they tend to use the police. And, there are problems associated with that, even if you use a different police force. On top of that, then layered on top of that, of course, you've got the ongoing issue, which I don't think anybody really saw coming to begin with, of, who's actually doing the job here? Is it the Court of Appeal or is it the CCRC? And, the test that there has to be a real prospect of conviction. And, the appeal court really bridled at the idea that there was some non-judicial organisation who was sitting, looking at evidence and deciding really whether there was, on the balance of probability, somebody was innocent or not. So they say that's our job, So that kind of conflict between the CCRC and the Court of Appeal is yet to be resolved.
You answered my question about independence, so you don't think there is. And what about the independence from the government rather than from the courts? What do you think?
Okay, so
because we heard of Karen Neller say they had problem with getting sufficient commissioners, and we know that depends on the Ministry of Justice. There is a bit of an incestuous position there, I believe.
Yes. Well, I think that's true. Although I would think that anybody who did apply to become a commissioner probably is doing it for the right reasons. I don't think anybody is going in there thinking, in a way, why would you do that job if you thought your role was only to kind of shore up the decisions of the Court of Appeal. Whether there should be a totally independent method for taking on commissioners, probably yes. I think there has been a problem that's developed in recent years, as far as I understand it, with the outgoing chair of the commission, who was also on the Judicial Appointments Board, for instance. So there's a little blurring of the edges there. And there is clearly going to be a fundamental restructuring of the CCRC now, with that chair having gone and Dria Bird coming in as an interim chair. And I think everybody knows that it's got to be reorganised. How fundamentally it will be, I don't know. But it will be an opportunity to introduce greater independence into it, and that's all to the good.
Indeed, but until we have the government deciding who the interim chair is, and in the case of Dame Dria Bird, she's an amazing person, and surely she has the leadership characteristics that we need. However, her position as a police commissioner and victims commissioner, that clearly has must have created some, or will create some issue in her case, because if we have to treat applicants of the CCRC as customers, as she suggested, then there will be a few of them, particularly the falsely accused in sexual offences cases, which will see her as part of the system who has shifted the balance toward the complainer. So I think we need to be more careful. But I understand now the Justice Committee is going to have a role in the appointment of the chair. So hopefully that will go some way towards creating some independence.
I do agree with you. Actually, one of the things I think my personal view is a sort of fundamental wrong direction that the judicial system has taken in the past couple of decades is, what I would call victimology. The effect of a crime of whatever sort on the victim is obviously a terrible thing, and they need to be looked after and supported, but only in a way that doesn't interfere with the judicial system itself and the processing. A crime which is committed by whatever crime it is, even if it's a crime against the person, in truth, it's a crime against the state, and it's the state that must determine, whether that crime has happened and what the appropriate punishment was. And the punishment really shouldn't have anything to do with the feelings of the victims, because some victims are far more articulate than others, some are less affected than others, and that has nothing to do with the crime that's been committed.
And let's face it, whatever penalties you give, how can you reinstate the victim? It's, for example, in the case of a murder, how can you reinstate them? No matter what you do, it will never reinstate them. So we can't look in that way. I think we have to look at the social consequences, which is try to rehabilitate these people and not offending again if indeed they have committed a crime. But you have touched upon this already. You have said already the multidisciplinary or specialist approach within the CCRC will be helpful, involving forensic scientists, psychologists, etc. But how about independent investigative journalism? Could that ever be part of the CCRC? You said they have to be separate earlier on. Can you explain that a bit in more detail?
Well, just to, as I said earlier, the role of journalism is to be there when a case falls through the bottom of the system. The journalism has to be separate from the systems of the state. And this is not just to do with miscarriages of justice or the CCRC or anything like that. And to the extent that journalism begins to work with and within the machinery of state, then journalism is not going to be able to do the job that it's there for. And so you must always maintain, as a journalist, you must always maintain an arm's length relationship with organizations like that. Now, having said that, the work of investigative journalists can be a tremendous resource to the CCRC, and they should, they have a tendency really to sort of to push journalism to one side. And I kind of faltered there for a minute, because the example I'm going to give is not actually to do with the CCRC, but in the Lucy Letby case, current miscarriage case in my view, the Thirlwall inquiry, which is as it were a similar kind of mechanism to the CCRC, doing a different job, but the Thirlwall inquiry, Lady Thirlwall dismissed the work done by investigative journalists as noise. Well, it's not. That the work that those people had done on that case should be regarded as a very important input to the work that Thirlwall inquiry is doing. And for Thirlwall inquiry, read the CCRC. The CCRC should approach journalism as a resource that it can draw on, whilst always maintaining that arm's length relationship.
I could not agree more. I think that is the job of the investigative journalist, is to hold organizations such as the CCRC accountable. So I agree with that.
I mean, in the past, in the past, I know there have been CCRC commissioners who were investigative journalists, and I find it hard to see how you can do both jobs. If you want to give up being an investigative journalist and become a CCRC commissioner, that's fine, but you've got to wave goodbye to the journalism,
But someone with that background, I think that could help in a way.
Yes.
And do you think there is enough transparency in how the CCRC makes its decision? Or could that be improved?
I don't think I'm really in a position to answer that one, and I'm not familiar enough with the way they communicate their results nowadays.
I see. And if there was any change at all that you could make to the CCRC and restructuring today, we've made a video a few weeks ago where we had imagined this amazing collaborative team, and then we went to assist to the Justice Committee evidence session, and it was a turn down because there was nothing like that. What changes would you make?
Well, I think, and this is difficult, I understand this entirely, but they need independent investigative resources. I think I'm correct in saying when I listened to the judiciary, their performance in front of the Judiciary Committee, that, they talked about actually going back to the original police force to ask them to look at something, and all experience of that, in my experience, that is never going to work. The police always, almost 100% of the time, the police will maintain that their original work was fine, and that we're not looking for any. People would be released by the appeal court, and the police would make statements outside saying we're not looking for anybody else. Well, what do you need to know? So you can't go back to the original police force. If you go to another police force, there's still a tremendous amount of kind of trying to maintain the reputation of the police as a whole. And so somehow, they have the powers to request paperwork and so on that other organizations don't have, but they really need their own investigative arm, in my view. And, this can only be achieved with resources, and that's, that's a subset of the whole argument about the CCRC. The governments of various stripes kind of felt that, we had all the Irish miscarriages, in the 70s and 80s, and then, we had the Runciman report, then we created the CCRC. It was the job done, but the job was not done because it's gradually been eroded over the years, and you need to seriously accept that has to be there, and this process of re-examining cases, is fundamental to getting the job done correctly, making sure that you're not locking people up for things they haven't done. And so until governments accept they have to pour very considerable resources into this, it's never going to work properly. And that, of course, is a subset of the way that the governments over the years have undermined the entire judicial system.
Indeed, but that also will have its limitation in any event, because we have seen this progression on the type of miscarriages of justice we have today, such as the Lucy Letby case and the post office case, where actually there was no crime. So any investigative work, when there hasn't been a crime, it would not lead to any result. It would be more, looking at authorities and how do they get to that stage, whether it is cover-ups, and that is a different type of work altogether, is it?
Well, I'm not sure. If there are cover-ups going on, I think that I'm just thinking about the post office, the Horizon cases, for instance.
Yes.
If there was a well-resourced investigative arm to the CCRC with the resources to go places and interview people under caution and that sort of thing, then, and the CCRC and the commissioners and the caseworkers have to be doing their job properly to say, this is one that needs looking at, the investigations need to take place. And I would have thought they would have been able to get to the bottom of what was going on with the Horizon system and the communication between Fujitsu and the post office at the highest levels, because they can go in and get hold of all the paperwork and so on.
Yeah.
you've got to have a system which actually identifies the things that need to be investigated before you can investigate them. That's true. But you know, if you have that investigative arm with those resources and those powers, then you know it's got to be better than the situation now.
Indeed. Now, I have a final question, and then you can add anything else that you wish. But given everything you have seen, do you still hold hope that the appeal system can change for the better? And what keeps that hope alive for you?
So what one has to understand about the appeal system, sort of beyond a situation where the CCRC have referred a case, is this issue of David Jessel, with whom I used to work, would always say in interviews, you know, you have to understand that the Court of Appeal is a court of law, not a court of justice. They are not there. They do not regard their job as being to try and sort out injustice. They simply want to make sure that there isn't something that's gone wrong in the judicial process. And it's really in the judicial process, not in the process of investigation or anything like that. But what, you know, and they are very concerned all the time to say, we do not usurp the role of the jury. You know, people are tried and judged in this country by juries, not by judges. Now, you know, yes, that's a very laudable aim. And, you know, to a certain extent, it needs to be maintained. But juries get things wrong. And there are certain cases, types of cases nowadays, where juries, in my view, are incapable of coming to the right answer for the right reasons. You know, I think in general, the jury system, you know, I'm the only person who subscribes to this theory, but I think in general, juries quite often come to the right conclusions for the wrong reasons. And that's why we're not allowed to see how they work. But in cases like the Lucy Letby case, which is a case with very, very complicated medical, scientific and statistical evidence, or in complicated fraud cases, and I sat on a jury in a major fraud case a while ago, and I know the difficulties that a jury, with all the constraints on the way in which they are supposed to work, because they're not just allowed to talk to one another and talk to friends or anything like that. Very, very tight constraints on the way juries can work. And they are, in these complex cases, they are not the best forum to get that right. Now, once you start to accept that and you start to look at other ways of dealing with these complex cases, then I think you can also start to deal with an appeal court which becomes more of a court of justice, a kind of second, you know, I mean, you will know a lot more about this than I do, and the Italian system has its faults, but Italian appeal courts are capable of doing that job correctly. So I think you've got to reorganize the jury system first, and then, you know, and then you can look at the appeal court and the way that works.
We are great supporters of juries, by the way, but I think juries need help, external help, particularly with expert evidence, and that is an important part of it. But an appeal court that can look at the facts, absolutely, because every institution's got an appeal to look at facts again, and it's just right that we have that.
Yes. Very true. Just a final word on juries.
Yeah.
In the Lucy Letby case that I'm involved in quite heavily at the moment, those people who wish to maintain that conviction will say in public, you know, in print, oh, you people like me, you know, you haven't sat through all the evidence like the jury has, you know, in a 10-month trial. Well, if you've ever been on a jury, you know damn well that juries do not hear all the evidence. They hear only the evidence that the lawyers choose to put in front of them. And when I was sitting on a jury in a fraud case, on several occasions over many weeks, we sent questions to the judge saying, you know, can we hear some evidence on X, Y, and Z? And we'd all be hauled into court, and the judge would say, no, you can't. You can only make your decision on what's in front of you. And so juries are almost invariably constrained by what the
Indeed.
adversarial system chooses to put in front of them, and that is a recipe for injustice and miscarriage.
I agree entirely. That half picture is certainly will lead to injustice, no doubt. So that really brings us to an end of today's conversation. Is there anything else you would like to leave with our community?
No, I don't think so. I think you've grilled me very efficiently, Anna. You've got everything that I can possibly add out of me.
Lovely. Thank you, Steve, so much for joining us and sharing your insights. It's been a real pleasure. Really appreciate your time. We'll hope to have you again, maybe to talk about Lucy Lebby, possible?
Very happy.
Brilliant. Thank you so much.
Okay, bye now.
Today's interview gave us a lot to think about, especially around how institutions like the CCRC operate. If you've got ideas, reactions, or your own top 3 changes you'd make, drop them in the comments below. We'd love to keep the conversation going. And don't forget to like, subscribe, and join us again as we sit and rise in this unique trial.